If you're designated as an executor in a will, this video is meant to be a few reminders and things to put in the back of your mind, what to look out for, and when you need to call an attorney. Ultimately speaking, when someone passes away and they designated you as their executor in their will, the will that they signed has to be submitted to the probate court and the county the decedent resided in within 6 months after their date of death. Kansas has a very quick turnaround time on that. Some other states extend that out to 2 to 3 years. However, Kansas requires just 6 months in order to submit a will. After 6 months and 1 day, if that will has not been submitted to probate court, generally speaking, that will is considered invalid and unenforceable. What you need to know: in a will, an executor is a person appointed by the signer of the will of who they wish to carry out the terms of the will and the administration of that person's estate. Administration is broken down into several tasks. It's a collection of assets and giving an inventory of those assets, location and finding of heirs and beneficiaries of the estate. It's finding and paying off creditors. It is the liquidation of the assets of the estate, arranging for the payment of taxes, and ultimately the distribution of the assets after all of the expenses have been paid off. That's what you'll be in charge of doing, but what most people don't know is that after the signer of the will passes away, an executor does not automatically become the executor. An executor is only designated and becomes active once probate has been established and that will has been admitted to probate. And that doesn't happen automatically. That requires you or another family member to hire an attorney, take that will to court, have the court go through the procedures to appoint you as the active executor. And so you may find out that if you try and take a last will and testament to a bank where the signer of that will had accounts and the signer died, the bank is not permitted to talk to you. They need to see something else. They need to see a court order that says that you are the active executor. You will be turned away from that bank and they won't be permitted to talk to you until you have that court order in hand. Do you need an attorney? In my experience, yes. Kansas, unfortunately, has one of the more complicated probate procedures in code as far as notification requirements, filing deadlines. So the question is, when should you call an attorney after a loved one passes away? You don't need to call an attorney right away after someone dies unless there's an issue that needs resolved. For example, if there's an ongoing business that needs to make payroll next week, if there are other matters that are pressing, perhaps if the decedent own rental properties and there are tenants that are holdover, need to be evicted, if you're worried about a house sitting empty and that it might be broken into while it's sitting empty, all those might trigger that you'd want to, as soon as you need to act, you can certainly hire the attorney and get the process started. However, you don't need to meet with that attorney. If there are no pressing issues regarding the decedent's administration, you can wait to meet with the attorney until after the funeral. And sometimes that allows for you to get a better knowledge of the estate. It allows for bills to trickle in, for account statements to trickle in, so you can get an understanding of what accounts are out there, what issues there may be regarding taxes and debts. When you meet with the attorney, you can start addressing those situations of what assets are known, what debts are known. So do you need an attorney? Yes. Kansas probate happens to be a very complicated procedure that has a lot of contingencies, hoops to jump through, and formalities that a lot of other states don't include. And even with that, there's multiple types of probate that can be done. Even within that, a good probate attorney is going to be meeting with you not only to guide you through the procedure at hand, but also to help you as the executor. One thing that needs to be known that when you're acting as executor is the liability that comes with it. Whoever is appointed as executor is considered a fiduciary of the estate, which means you are legally bound to carry out prudently the administration of the estate. And so that means if there is a fault in the estate, if money goes missing, if you don't file taxes, if you don't jump through the hoops that you're supposed to jump through, you are at fault personally. If money is imprudently spent or used and the judge finds that should have been used in this way, shouldn't have gone missing, they could find that you personally need to recompensate the estate to make up for their shortcomings. If you don't get the taxes filed on time for the decedent when they were supposed to, the IRS or the judge could find you personally liable for paying the penalties on the taxes. If steps are skipped or missed that needed to be done in order to administer the estate, they would find you personally liable. The attorney that you have as the executor is to help you go through just the hoops required, the procedure of serving as an executor, But the attorney is also there to help you avoid your liability. We are trained, we are familiar with the probate code, so we can tell you, break it down step by step of what your requirements are, what step is next, how to approach any given situation. And so an attorney serves as the advocate for the executor to help make sure that the estate is administered efficiently and properly, but also in a way that doesn't result in liability to the executor.